If you've been hearing warnings that green card holders need to leave the United States in 2026, or that permanent residents are being told to go back to their home countries, I know that that sounds absolutely terrifying. You've built your life here, your family is here, and suddenly you're seeing posts and videos claiming that everything is about to change. I want you to take a breath, because I'm going to walk you through exactly what's really happening, what these warnings actually mean, and most importantly, what you need to know to protect your status and your future. Let me start with the most important fact. There is no federal law, no executive order, and no official government policy that requires green card holders to leave the United States in 2026 or any other year. Your lawful permanent resident status has not been revoked. There is no mass deportation program specifically targeting people who have done nothing wrong and are living here legally. If you are a green card holder in good standing, meaning you have not committed certain crimes, you have not abandoned your residence, and you have not violated the terms of your status, then you still have the legal right to live and work in the United States indefinitely. That fundamental principle has not changed. So where are these warnings coming from, and why are so many people suddenly worried? Over the past several months, there has been a significant shift in immigration enforcement priorities and rhetoric. The current administration has issued multiple executive orders focused on border security, interior enforcement, and expedited removal procedures. There have been statements from government officials about reducing illegal immigration, increasing deportations, and making it harder for certain categories of immigrants to remain in the country. Some of these statements have been vague or broadly worded, which has led to widespread confusion and fear, especially among immigrant communities who are already feeling vulnerable. Additionally, there have been proposals and discussions in Congress about reforming the legal immigration system. Some of these proposals have included ideas like reducing the number of green cards issued each year, eliminating certain visa categories, or changing the rules around family-based immigration and employment-based immigration. These are legislative proposals, not laws. They have not been passed. They are being debated, discussed, and in some cases they're being used as political talking points, but they are not currently in effect, and there is no certainty that they will ever become law being proposed and what you need to focus on. Let's start with what has actually changed in terms of enforcement. Immigration and Customs Enforcement, known as IC, has been directed to expand its enforcement operations and to prioritize the removal of individuals who are in the United States unlawfully or who have committed crimes. This includes individuals with final orders of removal, individuals with criminal convictions, individuals who have committed immigration fraud, and individuals who are considered threats to public safety or national security. This is not a new category of deportable offenses. These grounds of deportability have existed in U.S. immigration law for decades. What's different now is that ICE has more resources, more personnel, and broader authority to carry out enforcement actions without as much discretion as they may have used in previous years. For green card holders, this means that if you have a criminal conviction that makes you deportable under the Immigration and Nationality Act, you may be at higher risk of being placed in removal proceedings now than you were a year or two ago. This is particularly true for convictions involving crimes of moral turpitude, aggravated felonies, drug offenses, domestic violence, firearms violations, and fraud. If you have any kind of criminal history, even if it's old, even if you've already served your sentence, and even if you think it's minor, you need to speak with an immigration attorney immediately. Do not assume that because you were not deported years ago, you are safe now. Enforcement priorities change, and what was once considered low priority may now be actively pursued. However, if you are a green card holder with no criminal history, no immigration violations, and no issues with your status, then you are not a target under current enforcement priorities. You are not being told to leave. You are not at risk of deportation simply because of increased enforcement. Your permanent residence is still valid and your rights under U.S. immigration law are still protected. Now, let's talk about some of the specific warnings and claims that have been circulating online. One of the most common claims is that green card holders who have been outside the United States for extended periods are being warned not to return, or that they will lose their status if they try to re-enter. Here's what the law actually says. If you are a lawful permanent resident, you are allowed to travel outside the United States. However, you must maintain your residence here. That means you cannot abandon your intent to live in the United States permanently. If you leave the country for more than six months, U.S. Customs and Border Protection may question whether you still intend to maintain your permanent residence. If you are outside the United States for more than 1 year without obtaining a re-entry permit, there is a legal presumption that you have abandoned your status. This rule is not new. It has been part of U.S. immigration law for many years. What has changed is that CBP is now enforcing this rule more strictly. Officers at ports of entry are conducting more thorough secondary inspections, asking more detailed questions about why you were abroad, what ties you have to the United States, and whether you maintained your residence while you were away. In some cases, green card holders who have been outside the country for extended periods have been referred to immigration court for further proceedings. This does not mean they were automatically deported. It means that CBP had concerns about whether they had abandoned their residence, and those concerns need to be resolved by an immigration judge. If you are planning to travel outside the United States for more than six months, or if you have already been abroad for an extended period and you are worried about re-entering, there are steps you can take before you leave. You can apply for a re-entry permit by filing Form Y-31. A re-entry permit allows you to stay outside the United States for up to 2 years without being presumed to have abandoned your status. It's not a guarantee that you won't face questions when you return, but it significantly strengthens your case. If you are already outside the country and you did not get a re-entry permit, you should gather as much documentation as possible to show that you maintain ties to the United States while you were away. This can include evidence of property ownership, employment, family relationships, tax filings, bank accounts, and any other proof that you intended to return. Another claim that's causing confusion is that green card holders are being warned to leave because of changes to public benefits rules. There was a policy implemented a few years ago called the public charge rule, which made snorts it harder for immigrants to get green cards if they were deemed likely to become dependent on government assistance. That rule has gone through multiple legal challenges and revisions, and the current version is less restrictive than it was at its peak. However, there is still concern among some immigrants that using public benefits could put their status at risk. Let me be very clear about this. If you are already a lawful permanent resident, using public benefits like Medicaid, food stamps, or housing assistance does not automatically make you deportable. The public charge rule primarily affects people who are applying for green cards, not people who already have them. There are some very limited circumstances under which a green card holder could be found deportable for becoming a public charge, but those circumstances are extremely rare and require a showing that you became a public charge within 5 years of your admission, and for causes that existed before your admission. This is not something that happens often, and it is not something that you need to panic about if you are already a permanent resident and you are using benefits that you are legally entitled to receive. That said, if you are planning to apply for U.S. citizenship in the future, you should be aware that USCIS will review your entire immigration history as part of the naturalization process. If you have received significant public benefits, it's possible that could be a factor in their evaluation of your good moral character, although it is not an automatic bar to citizenship. If you're concerned about this, speak with an immigration attorney before you file your citizenship application. Now, let's address the warnings about proposed legislation. There have been bills introduced in Congress that would reduce the number of green cards issued each year, eliminate the diversity visa lottery, limit family-based immigration to immediate relatives only, and prioritize employment-based immigration. Some of these bills have also proposed changes to the rules around deportability and inadmissibility. These proposals have generated a lot of fear, especially among people who are waiting for green cards or who have family members waiting to immigrate. Here's what you need to understand. Proposed legislation is not law. In order for a bill to become law, it must be passed by both the House of Representatives and the Senate, and it must be signed by the President. That process can take months or even years, and most bills that are introduced in Congress never become law. Even if a bill does pass, it typically includes effective dates and transition rules that govern how it applies to people who are already in the immigration system. Laws are almost never applied retroactively to take away rights or status that people already have. If you already have a green card, proposed legislation about reducing the number of green cards issued in the future does not affect you. Your status is not going to be revoked because Congress passes a law limiting future immigration. If you have a pending family petition or employment petition, that's a different situation, and you should monitor legislative developments closely and consult with an attorney about how proposed changes could affect your case. Let me also address something that's causing a lot of anxiety among families. Some people are hearing warnings that green card holders should leave the United States and return to their home countries to avoid being deported later. This advice is not only wrong, it's dangerous. If you voluntarily leave the United States and give up your permanent residence, you cannot simply come back whenever you want. You would need to apply for a new immigrant visa, go through the entire green card process again, and wait in line just like any other applicant. Depending on your country of origin and your visa category, that could take years or even decades. If you leave voluntarily, you are giving up one of the most valuable immigration statuses you can have. The only situation in which it might make sense to leave the United States voluntarily is if you are already in removal proceedings, you have exhausted all of your legal options, and an immigration judge has ordered you deported. In that case, leaving voluntarily instead of being removed can sometimes make it easier to apply to return in the future. But that decision should only be made after consulting with an immigration attorney who has reviewed your entire case. So, what should you be doing right now to protect yourself and your family? First, and most importantly, if you are eligible to apply for U.S. citizenship, this is the time to do it. Citizenship provides stronger legal protections than permanent residence. Citizens cannot be deported. Citizens cannot lose their status for traveling abroad. Citizens have full voting rights and full access to federal benefits. If you have been a permanent resident for at least 5 years or 3 years, if you are married to a U.S. citizen and you meet the other eligibility requirements, you should seriously consider filing Form N-400 as soon as possible. Do not wait to see what happens with new policies or new legislation. The longer you wait, the more uncertainty you face. Second, make sure all of your immigration documents are current and in order. Check the expiration date on your green card. If it has expired or will expire within the next 6 months, file Form Y-90 to renew it immediately. Make sure USCIS has your current address on file. If you have moved and did not notify them, file Form AR-11 online. If you have any pending applications or petitions, check the status regularly and respond to any requests for evidence on time. These are basic administrative steps, but they matter, especially when enforcement is being ramped up. Third, if you have any criminal history whatsoever, even if it's something you think is minor or old, consult with an immigration attorney right away. Do not assume that because you were not deported at the time of your conviction, you are safe now. Immigration law is complex, and the same conviction can have different consequences depending on how it's classified, when it occurred, and what relief you might be eligible for. An attorney can review your criminal record, analyze your deportability risk, and advise you on whether you should take any action such as applying for a waiver or filing for citizenship before ICE initiates removal proceedings. Fourth, know your rights. If you are stopped by immigration officers, whether at the border or inside the United States, you have the right to remain silent beyond confirming your identity. You have the right to ask for an attorney. You do not have to consent to a search of your home unless the officers have a warrant signed by a judge. If you are placed in removal proceedings, you have the right to a hearing before an immigration judge, the right to present evidence, and the right to appeal. Do not sign any documents without understanding what they are. If an officer asks you to sign a Form 1407, which is a voluntary abandonment of your permanent residence, do not sign it unless you have spoken with an attorney and you fully understand what you are giving up. Fifth, have a family preparedness plan. Make sure your spouse or a trusted family member knows where your important documents are kept, including your green card, passport, birth certificates, marriage certificate, and any immigration paperwork. Make sure they have access to your financial accounts and know how to contact your employer and your immigration attorney. If you have minor children, consider creating a power of attorney or a guardianship plan so that someone can care for them if you are detained. These steps can make a huge difference in a crisis. Let me also remind you where to go for reliable information. The best sources are official government websites. USCIS publishes policy updates and guidance at USCIS. GUI, the Executive Office for Immigration Review, provides information about immigration court at Justice.gov. U.S. Customs and Border Protection publishes travel information at cbp.gov. The Department of Homeland Security publishes enforcement statistics and policy announcements at DHS.gov. These are the authoritative sources. If you see a claim on social media, verify it by checking one of these official sites or by consulting with a licensed immigration attorney. Be very careful about who you trust for legal advice. Only licensed attorneys and accredited representatives recognized by the Department of Justice are legally allowed to provide immigration advice for a fee. If someone offers to help you, but they are not an attorney or an accredited representative, they are breaking the law, and you could end up losing money or even your status because of bad advice. If you need help, go to the American Immigration Lawyers Association website at alaw.org and use their lawyer referral service. The information I'm providing in this video is general education. It is not personal legal advice. Every immigration case is different, and what applies to one person may not apply to another. If you have specific questions about your situation, you need to consult with an attorney who can review your individual circumstances. Let me bring this all together. The warnings you're seeing about green card holders needing to leave the United States in 2026 are not based on any official government policy or law. They are based on fear, speculation, and misunderstanding of complex enforcement changes and legislative proposals. Yes, enforcement has intensified. Yes, there are proposals to change the immigration system, but no, permanent residents are not being told to leave. Your status is still valid, your rights are still protected, and the law has not been rewritten overnight. What you need to do is stay informed, stay prepared, and take action where action is needed, especially if you are eligible for citizenship. If you found this video helpful, please subscribe to Immigration Updates Hub so you can stay informed as developments happen. Share this video with anyone in your community who might be feeling scared or confused right now. Accurate information can make all the difference. Leave a comment below if you have questions about green card status, travel, or citizenship, and I'll do my best to address them in future videos. Thank you for watching, and I'll see you in the next.